Yes. Our earnest request to media is that to be more responsible. Let us we all make an effort to bring the peace and tranquility in the state, and we all shall behave more responsible citizens. And therefore, we are not saying anything against media. We are not on that issue. The only request is that we are doing the live streaming. Our only request is that the media may see its responsibility. It is the fourth pillar of democracy, and therefore they may be more responsible. Thank you.
Lord, I have to make another request, my Lord.
Yes.
Lord, we the lawyers, this side or that side, that apart, Lord, a much bigger responsibility lies on our shoulder, not to give it a color of any religion. And let us restrict our argument only with regard to, my Lord, what is there in the rule book or in the constitution. That's the only request, Lord. And one more, Lord, submission is this, Lord, at the very outset. Lord, we have filed an intervention application on behalf of Lawyers for Just Society.
Yes.
I don't know whether if your Lordship have received, because we have filed it online. If your Lordship could be kind enough to get, my Lord, and a compilation of judgment as well.
Lords, I am on my legs. All these intervention applications cannot, my Lords, can be heard, my Lords, at the appropriate time. My Lords, I was making submissions.
We have not received any such application till now.
Mr. Amrutesh is, my Lord, there in the courtroom. Our counterpart, my Lord, in Bangalore.
They may file it. They may file it in the counter. There is an urgent counter where they can file the application, and that will come to court.
That has been done.
Yes, Mr. Kumar.
That's a very important submission. May I request the court to kindly.
Please open the mic. Mic is. Yes.
They are making two applications.
Making applications, all have to be filed in the counter, not in the court. We have stopped this practice.
No, with great respect. Urgent application is for this purpose.
All urgent application, there is an urgent counter in the registry where you can file the urgent application. They will be same day sent to the court.
Very good. That event may make some.
We are unable to hear. Yes.
Lords, may I resume, my Lord?
Yes, just a minute. Some senior advocate is making a request at the dais. Yes.
We have already furnished a copy to.
All right, you file it in the counter. Tell them the matter is listed today. They will send it to the court.
And all that I praise. We take some time of getting instructions.
Let it come before us. Let it come before us. Yes. Yes.
Yes, may it please, my Lord.
Mr. Kamat.
Yes, my Lord. May it please, my Lord. My
Yes.
Lords, your Lordships were kind enough to give us almost 2.5 hours, my Lord, on Thursday. My Lords, I was making submissions on this GO of 5th of February. And my Lords, I had, my Lords, broadly submitted that this application, this GO, my Lord, suffers from a total non-application of mine, number one. And number two, my Lords, that this GO is in the teeth of Article 25. Now, my Lords, if I can invite you to kindly go back to the GO, because I had very little time on that day to actually place the entire GO.
Yes.
That translated version of the GO can be just placed.
Yes.
Where is the translated version of the GO?
Yes, my Lord. As mentioned in the above at reference number 1, the Karnataka Education Act 1983, passed by the government, stipulates that all school students studying in Karnataka should behave in a fraternal manner, transcend their group identity, and develop an orientation towards social justice. Under Article 130, Section 133 of the above law, the government has the authority to issue directions to schools and colleges in this regard. Above mentioned circular at reference number 2. Kindly see this, my lord. This is a circular of 31st of January 2014. Underlines how pre-university education is an important phase in the lives of students. All the schools and colleges in the state have set up development committees in order to implement policies in line with the policies of the government, utilize budgetary allocations, improve basic amenities, and maintain their academic standards. It is recommended that the schools and colleges abide by directions of these development committees. As such, supervisory committee in schools and colleges, SDMC in government institutions, parent teachers institutions, associations in the management in private institutions should strive to provide a conducive academic environment and enforce a suitable code of conduct in accordance with the government regulation. Such a code of conduct would pertain to that particular school or college. Various initiatives have been undertaken to ensure students in schools and colleges have a standardized learning experience. However, it has been brought to the Education Department's notice that students in a few institutions have been carrying out their religious observances, which has become an obstacle to unity and uniformity in the schools and colleges. The question relating to a uniform dress code over individual dressing choices has come up in several cases before the Honorable Supreme Court and High Court, which have ruled as follows. So 3 decisions are cited, my lord, and I'll come to it specifically, but I'll skip it for the moment. And then, my lord, the next page, the conclusion which the government assumes flows from these decisions is, as mentioned in the above mentioned rulings of the Honorable Supreme Court and High Courts, since there is a prohibition of headscarf or a garment covering the head is not a violation of Article 25 of the Constitution. Additionally, in terms of the Government Education Act 1983 and its rule, the government has decreed as follows. Over the page, my lord. We are really not concerned with government schools in my petition, but I'll read it. In the backdrop of the issues highlighted in the proposal, using powers granted by the Education Act, Section 133(2), all government schools in the state are mandated to abide by the official uniform. Private schools should mandate a uniform decided by their Board of Management. In colleges that come under the Pre-University Education Department's jurisdiction, uniforms mandated by the College Development Committee or the Board of Management should be worn. In the event the management does mandate a uniform, students should wear clothes that are in the interest of unity, equality, and public order. So, my lord, 2 things which the GO says in substance is, number 1, wearing of headscarf is not protected by Article 25. Specific finding, a declaration made by the state government. Number 2, we leave it to the College Development Committee to decide whether these uniforms should be uniform or some exemptions can be made, headscarf can be allowed, etc. Discretion of the College Development Committee. Now, my lords, on the first aspect, I respectfully submit that this declaration, which is there in the penultimate page of the GO, that wearing a headscarf does not fall under Article 25, is totally erroneous. And I'll demonstrate and make that good. Number 2, as far as this delegation to a college development committee to decide whether to permit students to wear a headscarf or not, that itself is totally illegal, because lordships are aware that under Article 25, the only restriction which probably comes to the aid of the state in restricting that fundamental freedom is public order. Now, public order is a state responsibility. It is a responsibility of the executive. Lordships are aware. Entry 1 of list 2 of the 7th schedule, item 1 itself, public order, it's state's responsibility. The question which will arise for your Lordship's consideration is, a college development committee consisting of some MLA and subordinates will today decide whether exercising this fundamental freedom under Article 25 is permissible or not. They have been a third party, an extra statutory authority has been made the guardian of Article 25, which according to me under our constitutional scheme is totally impermissible. So, my lord, these are the broad, my lord, arguments which I want to make as far as this GO is concerned. Now, my lords, kindly have first, my lord, Article 25. Lordships have seen this time and again, my lord. But for my satisfaction, if your Lordships can just have Article 25 again. Subject to Article 25, freedom of conscience and free profession, practice and propagation of religion. Subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. So, my lord, as far as this case is concerned, we are not concerned with morality, my lord, or health. So the only restriction which probably aids the state as far as this freedom is concerned is only public order.
Question is whether this right conferred under Article 25
yes, my lord,
is absolute.
Yes.
Whether it is an absolute right or a relative right subject to certain restrictions.
Yes, I bow down to that, my lord. That's really the heart of this question. Lordships have put the, my lords, hit the nail on the head. And my lords, the answer is 2 or 3-fold. Article 25 rights, my lord, are not subject to general reasonable restrictions as under Article 19. The restriction on Article 25 is envisaged in Article 25 itself, and that is public order, morality, and, my lords, other provisions of this part.
Article starts with the word subject.
Yes, correct. I'm grateful.
What does it mean?
Yes, I'll explain that, my lord. I'll explain that, my lord. Lords, as I, my lords, develop my presentation, I will show, my lord, that public order as a concept which your lordships have evolved is, my lord, not a mere law and order disturbance. As your lordships court have described, my lord, that law and order, public order and security of state, these are in concentric circles. And therefore, my lord, a public order issue is a higher form of, my lord, a law and order issue. Now, my lords, when we are actually seeing whether a particular practice, my lord, disturbs public order, there are several facets to it. And one of the facets which your lordships will consider is whether the practice by itself leads to a problem of public order. Now, my lord, there are practices like, for example, in that.
What is public order? What is public order? First, please.
Yes, my lord. I
throw some light on the public order. What amounts to public order?
Yes, my lord. My lord, where there is a heightened sense of, my lord, law and order issue, definitely, my lord, it will be an issue of public order. And, my lord, the state has a responsibility to maintain public order. There is no denying that fact, my lord. But what I am submitting for your lordship's consideration is this. My lord, there is a concept and which the Supreme Court has accepted called the heckler's veto. And it means, my lord, that I go on the street and, my lords, I am walking. somebody heckles me and said, you can't come on this street. Can it be said, my lord, that because I am heckled, this is the issue of public order and we stop the movement on the street? Similarly, my lord, this issue has arisen in the context of freedom of speech. My lords, there are certain movies which are made.
Come straight to this issue itself.
Lords, I'll come to this.
Whether it involves any public order or not.
Lords, I'll make that good, my lord. I'll make that good. I'll make that good, my lords.
Yes.
My lord, in a movie, my lord's case which the Supreme Court has, my lord, recently decided. My lord, there are, my lord, provocative, my lord, probably scenes which are there in that movie. It may not be palatable, my lord, to some sections of the society. The question is, my lord, because of those unpalatable scenes, there is a problem which might be created of public order. Can you, my lords, restrict the freedom of speech? And the courts have taken the view, my lord, that it is for the state to create a conducive, a positive environment.
We are not on that issue.
Yes, my lord.
Not on that issue. We are only trying to understand.
Yes, my lord.
As to whether by putting this government order by the state government has in any manner envisaged had restricted Article 25 or not.
Grateful, my lord. Great. That's the heart of it, my lord. Lord, I was just giving a background, my lord, of how I am going to present this issue of infringement of Article 25. And the issue is this, my lord, that the state has a positive duty, my lord, that to ensure that people are able to exercise their fundamental rights. It is no ground, my lord, that certain sections of society don't want some other sections of society, my lord, fundamental rights to play out. It's not a ground for, my lord, restricting the fundamental rights of that section of the society. That's the point which I was trying to make. Lord, just before I come to this, my lord, I was, my lord, primarily on this declaration in the GO that the prohibition of headscarf is violative of Article 25. And this, I submit, my lord, is a wrong declaration of law.
Whether by this government order, the state government has put any prohibition of wearing the...
I say with, yes, I say with respect, my lord, with utmost humility, yes. Just have a look at, my lord, what has, my lord, it is not an innocuous, my lord, delegation to the College Development Authority.
Yes.
My lord, it is not an innocuous, my lord, delegation to the College Development Authority. The state says that wearing of a headscarf is not an essential part of Article 25 and then goes on to delegate. Now,
before that, they say, as mentioned in the above rulings.
Yes, that's why I wanted to point the rulings.
This is what their understanding is.
That's right, my lord.
That on the basis of that ruling,
correct,
that it is said. Now,
yes,
this is their understanding.
That's right.
They have not put any prohibition.
I am saying it's a wrong understanding.
What we see from it, that as mentioned in the above mentioned rulings of the Honorable Supreme Court and various High Courts, correct, since the prohibition of a headscarf or a garment wearing head is not a violation.
Is not a violation. I am challenging this, my lord. I am challenging this. Now, straight away, my lord, if your lordships can have this compilation number 1, which I have handed over on this point. My lords, compilation number 1. If my colleagues can help the court master to hand it over to the Honorable Court, please.
No, before we switch over to the rulings.
Yes, my lord.
First, let us first understand.
Yes.
The Article 25.
Yes.
Now come to Article 2 of Article 25.
Yes, my lord. Yes, my lord. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with the religious practice. So there has to be a law, my lord. There has to be a law which can regulate the economic, financial, political, or other secular activity associated with the religious practice, and B, providing for
It
social welfare.
provides two things.
Yes,
Nothing in this will prevent the state government
correct.
from the effect of the operation of any existing law. If there is any existing law that can continue, it will not be affected, or prevent the state from making any law with respect to regulating, restricting any economic, social, political, or other secular activity
That's right.
which may be associated with religious practice. My brother wants some clarification.
Yes, my lord. Yes, my lord.
The
Yes,
expression law employed in part 3
yes, my lord.
is generic,
Yes, my lord.
and clue can be had from Article 13,
Yes, my lord.
Clause 3.
Yes, my lord.
Yes, it's very
I'll
generic.
read it, my lord.
Yes. It includes all instrument, legislation
All in this article,
and
unless
legislative instruments.
I am grateful, madam. I am grateful, madam. In this article, unless the context otherwise requires, law includes an ordinance, order, bylaw, rule, regulation, notification, customs, or usage having in the territory of India the force of law. I am grateful, my lord. I am grateful, madam. There is absolutely
Wider than what John Austin had said.
That's right, my lord. That's right. And that, my lord, lordships will also see, it also includes, my lord, pre-constitution, my lord, that is excluded as far as this is concerned. So, my lord, lordships are absolutely right. It includes delegated legislation which flow from the primary source of law. My lords, I bow down to that. So, my lords, there are two restrictions, as my lord, the Honorable Chief Justice, my lord, put it to me. One is public order, morality and health. And second, my lord, the state is not prevented from making any law restricting any economic, financial, political, or secular activity which may be associated with the religious practice. So the question, my lord, one of the questions which will fall for consideration is whether a particular activity, my lord, is a secular activity connected with religion, or it is an essential. That is what, my lord, on the first day itself, my lord, put it to me, and we will make that good. So, my lord, coming back to these judgments on this very aspect as to whether it is an essential part of religion, my lord, we have enough of judicial authority, which I want to, my lords, place for my lord's consideration as a matter of persuasive value. It's not binding on your lordships, but, my lord, two different high courts, my lord, Kerala and, my lords, Madras, have taken a view which might assist your lordships, my lord, in, my lords, understanding the contours of this case. If I can just place, my lord, the volume 1 of that compilation, and just one or two judgments here, my lord. It'll just take 5-10 minutes. Volume 1, my lord. Serial number 4, my lord, is a judgment of the single judge. I'll cite the single judge decisions, and this has been affirmed by the division bench. It starts at, my lord, page 24. And the issue was here, my lord, that the petitioner was a candidate appearing for the CBSE, my lord, the medical entrance test, and she wanted to wear a headscarf, which was not permitted. And lordships will see the question which arose at page 24. The prescription of dress code for All India Medical Entrance Test 2016 is questioned in this writ petition. The first petitioner is a candidate appearing for the entrance test. Second petitioner is the father. Then, my lord, paragraph 4. In a country like India, a predominantly religious society, the court will have to examine the religious freedom in the light of the constitutional scheme, what your lordships also put to me. The religious freedom to profess, practice and propagate is a fundamental right subject to public order, morality and health as provided in 25(1). There are occasions in matters of public affairs or related secular activities leading to instances of conflict between religious practices and state interest. Exactly, my lord, the issue here. Essentially, this conflict veers around religious practices rather to freedom of conscience, the courts are often called upon to decide the question of conflict between the right of religious freedom and the state's duty to regulate public affairs in matters of general nature or secular activity. That is 25(2). Therefore, the individual's religious rights, when entangled in public law, have to be resolved by the court by assimilating individual rights and state interest. Then, my lords, Bommai is cited, which is, my lord, it's a secular republic. Then, my lords, I will not trouble your lordships with all the other citations. Then, my lord, kindly turn to para 28. Page 28, well, I'm sorry, page 28, para 13.
I'm sorry to interrupt my learned friend, my lord. If he can share a copy of the index, my lord, it will be.
Yes, we'll just do that. I'll request, if you can, sir, give me your mobile number. I'll just ask them to WhatsApp the entire.
You can just send it by email to instructor.
Yes. Shahul, just organize this, please.
Thank you.
Page 28, para 13. In dealing with the question of freedom of religious practices, the court must dwell on to find such practices are essential to maintain the identity of a person to profess his faith in the religion he practices, and if not allowed, whether it would result in the wrath of injunctions of the religious doctrine he professes. One of the salient features of the religious tenets is the moral obligation that one has to carry in formulating his conduct in obedience to the command of superior power, in manner his conduct to be conducive to become more obedient to the legal obligation or legal duty under the temporal law. This moral obligation cannot be allowed to be interpolated by outside ethos. If the religious tenets do not allow a woman to become a priest, the state cannot import secular ethos of gender equality to allow a woman to be appointed as a priest. So this is, my lord, the broad contours of the essential religious practice test. And then, my lord, the court then goes on to, my lord, the core issue, which is, my lord, page 29 in that case, about the dress code. Coming back to the core issue in the writ petition about the dress code, it is to be noted that Islam embraces and encompasses the guidance to the humans in all walks of life. Shariat is Islamic law. Sharia contains of two things: law revealed through the Quran. Number two, the laws that are taken from the lifestyle and the teachings of the Prophet Muhammad. This part is called hadith. And even in mullahs, lordships have seen Muslim law. This is the primary source of Islamic law. The Holy Quran consists of a broad and general prepositions. It is often, though hadith Quranic prepositions are interpreted or explained. Therefore, the validity of expected conduct of the believer rests on the credibility of reporting of hadiths as well. The whole idea of Quranic injunctions and hadiths is to reduce the rights and obligations to formulate certain standards of behavior of individuals in his conduct in obedience to the commands of God. This presuppose to bind his own behavior as well as the community. Then, my lord, kindly turn to the relevant verses as far as this headscarf is concerned, which is at page 30. Para 20. Para 19, I'll read. The petitioner's concern is that the dress code as now prescribed would not allow the candidates to wear the headscarf and full sleeve dress. It is the case of the petitioner that the Sharia mandates women to wear the headscarf and full sleeve dress, and therefore any prescription contrary is repugnant to protection of the religious freedom as provided under Article 25. Therefore, this court has to examine the nature of dress code prescribed for women in Islam, and such practice is an essential part of religion or not. And if it forms part of essential practice, can it be regulated in the light of Article 25(1)? So this is the core question, my lord, which fell in that court, which fell for consideration, my lord. And they cite, my lord, in chapter 24, verse 31, which reads, my lord, and tell the believing women to lower their gaze and to be modest and to display of their adornment only that which is apparent, and to draw their veils over their bosoms, and not to reveal their adornment, save to their own husbands or fathers, or husbands' fathers, or their sons, or their husbands' sons, or their brothers, or their brothers' sons, or sisters' sons, or their women, or their slaves, or male attendants who lack vigor, or children who know not of women's so and so, and let them not stamp their feet so as to reveal what they hide of their adornment. So, my lord, a specific, my lord, injunction in verse 31, which is based on, my lord, that modesty has to be protected, that they have to draw their veils over their bosoms. And then, my lord, para 22, they, in the original text, my lord, they say that the veil is referred as khumur, and khumur or head cover is the cloth which covers all the hair on the head, while the word juyub means not only the bosom as commonly thought, but it includes the neck too. Then, my lords, paragraph 24.
What is khumur?
My lords, khumur, my lord, that is what they have explained, my lord, is a head cover. Head cover in Arabic, that is the cloth which covers all the hair on the head. Lord, that is probably a headscarf. Your lordships are right, my lord. That's
Whether
probably
khumur
a headscarf.
amounts to hijab?
Yes, my lord. I'm grateful, my lord. I'm grateful, my lord. Lords, over the page, page 31, my lord. Lords, over the page, para 20, para 23, my lords, verse 59 is quoted, which also, my lord, is in the similar vein, and para 24, my lord. Lord, just to on the side, Lord, I am citing all these verses. Lord, it is being, lordships are absolutely right, my lord, that people should not report all this in the media, because, my lord, there is a controversy that I, as a Hindu, my lord, I am citing this. I am only doing my duty, my lord, as to assist your lordships, my lord.
You are a lawyer first.
Yes, my lord. That's right, my lord. That's
Lawyer
right.
first.
That's why, my lord, what your lordship said right in the beginning, that the media should be more responsible, my lord, I absolutely agree. I couldn't concur more, my lord. My lord, so now all this is analyzed, and para, my lord, 29, page 32, over the page, my lord. Thus, the analysis of Quranic injunctions and hadiths would show that it is farz. I'm sorry, my lord. My lord, the Chief Justice got it?
Yes.
Yes. Thus, the analysis of the Quranic injunctions and hadiths would show.
Yes. Yes. Yes.
Show that it is a farz to cover the head and wear the long sleeve dress except face part, and exposing the body otherwise is forbidden haram. When farz is violated by an action opposite to farz, that action becomes forbidden. However, there's a possibility of having different views or opinions for the believers of Islam based on independent reasoning. The court is not discarding such views. The possibility of having different propositions is not a ground to deny the freedom if such propositions have some foundation in the claim. As has been adverted above, the claim of the petitioner is well founded, even though a different view is possible. This court is only expected to safeguard such freedom based on the Constitution in preference to giving a religious verdict. Lords, I just pause here for a minute. My lord, what the court is saying is very, my lords, weighty. And this is also fallen for consideration in that Vijay Emmanuel's case, my lord. If, my lord, there is a practice which the believer thinks, my lord, is a part of his faith, and that practice by itself is innocuous, it is not something, my lord, which by itself violates public order. By itself, my lord, it does not infringe anybody else's freedom. So therefore, my lord, in that context, actually, my lord, the test of essential religious practice will not actually arise, because this is simply a facet of an
Is it your
innocent-
case?
Yes.
Is it your case that these students
Yes, my lord.
who are insisting for wearing this headdress, they had been practicing this for considerable time?
I am absolutely grateful for this question, my lord. As far as the petitioners in this case, it's a pleaded case, my lord, that right from their admission in this PU college, we had been going there, my lord, with a headscarf, and we were wearing a headscarf, my lord, of the same, my lord, there is no difficulty, of the same uniform, till this GO came, my lord, and said headscarf is not a...
Since
Yes.
when? Since when they were going on this?
For last 2 years, my lord, I've said that in my writ petition. No, these are second year PU students. I've said that in my writ petition, my lord. I'll draw the lordship's attention to the paragraph numbers also, but kindly make a note that it is my case that we have been wearing a headscarf. There was absolutely no trouble.
Since admission, you had been wearing it.
Yes, my lord. I'm grateful for that question, my lord. So that will, my lord, probably put things into perspective. And this is not a case, my lord, where the students are insisting for a different uniform, that I will wear something else other than the prescribed uniform. They are only saying, my lord, that they will only cover their head, and not only with not with a different color, with the same color as the uniform which is prescribed. And according to me, my lord, this is an innocuous practice, and considering the, my lord, broad width of fundamental freedoms enshrined in the Constitution, the state should facilitate that exercise of that freedom, my lord. That's the submission. Then, my lord, page 32, paragraph 30, I'll just finish this, my lord. The discussions above, as would show that covering the head and wearing a long sleeve dress by women have been treated as an essential part of Islamic religion. It follows a fortiori that Article 25 protects such prescription of the dress code. And B.J. Emmanuel is quoted, my lord, which Mr. Hegde also cited that day. And then, my lord, para 32, also the same thing, the right of women to have a choice of dress based on religious injunction is a fundamental right under Article 25(1). When such prescription of dress is an essential part of religion, as has been noted above, the right can be negated only in the circumstances mentioned in 25(1). And ultimately, my lord, they were permitted to, my lord, wear that headscarf in the medical entrance test. Now, my lord, this came up before the division bench, and the division bench, my lord, judgment is the next judgment, which is page 35. The CBSE challenged this, my lord. And during the pendency, my lord, of this writ appeal, the government, the CBSE came out with a notification, my lord, where, my lord, certain measures were put in place. And one of the measures was that if you are wearing a religious dress like a headscarf, etc., you should come in half an hour or 1 hour earlier so that security, etc., can be looked at. Those girls can be properly checked before they enter the examination hall. And that is, your lordships will find at page 37. The judgment starts at page 35. The subsequent notification which came during the pendency of that writ appeal is noted at page 37. And the court notes it in paragraph 5. A copy of the notification issued by the CBSE was also made available to the learned counsel appearing for the writ petitioners and the learned Assistant Solicitor General of India appearing for the Union of India. It is evident from the notification dated 26 April 2016 that the candidates coming in customary religious dress are permitted to appear, subject to the rider that they report to the center by 8:30 a.m. for proper frisk screen. Nobody can have any objection, my lord. If you are insisting on wearing something which the state feels needs more security check, etc., those kind of restrictions can definitely be put in. With those observations, my lord, this writ appeal was disposed of. My lords, while I am at this juncture, my lord, I also want to point out one thing. In fact, my lord, the Kendriya Vidyalayas, my lord, sir, when I am on this law, I just want to complete this. We have filed a memo, my lord. The Kendriya Vidyalayas even today they permit, my lord, by a notification that even though they have a uniform, as far as Muslim girls are concerned, my lord, they are permitted to wear a scarf matching with the bottom wear with the red hem on the corners. Not that memo we have just filed, my lord, just if your lordships can just have a look at that. Not just to, my lord, because even at the national level, my lord, this has been the tradition, my lord, that governments have permitted headscarves to be worn even in Kendriya Vidyalaya. Just have a look at, my lord, page, my lord, this is the uniform which is prescribed. Just have a look at page 3, my lord, of that. Now, I'm not saying this will actually, my lord, bind the case either which way, but just a relevant consideration, I thought, my lord. Page 3, if your lordship sees, scarf for Muslim girls, gray color scarf matching with the bottom wear with red hem on the corners. And see also, my lord, as far as Sikhs are concerned, also that headgear allowance is there, my lord. So this is in line with Article 25, my lord. Yeah. Now, my lords, the next judgment which I wanted to cite is another DB judgment, which is in this compilation, my lord, at page 13. Justice AP Shah, my lord, and Justice Chandru. And here, my lord, the question which arose was that the Election Commission, my lord, had asked everyone, my lord, to give their photographs for the purposes of electoral rolls. And that was challenged, saying that, look here,